You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. You should go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You should read it despite the fact that he's not wearing a coat today. Bill, what is up with that?
Well, it's pretty simple. In Death Valley today, it's cooler than on the street outside of the studio. So I just decided to call a moratorium on suits until it cools off.
Right on. Well, privileges come with seniority. So
well, and also,
congratulate you on your.
And also, I'm just not a practicing lawyer anymore, so I don't have to wear the lawyer uniform.
Right, you don't have to worry about pissing off a judge.
That's
All
right.
right. Speaking of judges, let's jump into it. We have a Judge of the Week to kick us off here, and we're going to venture far outside New York and Delaware, all the way out to Oklahoma City, and we're going to talk about Judge Sarah A. I understand she has an opinion that could end up affecting Wall Street lenders. What's going on here?
Very interesting case called GMX. That is an oil and gas exploration and production company, as you guess, in Chapter 11 out in Oklahoma. This is a twist on the question of whether or when make-whole premiums are enforceable in bankruptcy. This isn't the usual kind of a case because, for the most part, make-whole premiums are being upheld in bankruptcy. And by the way, what a make-whole premium is, it arises in a situation in which the interest rates have declined, and ergo, many loan agreements say that if the loan is paid off early, you are liable for this make-whole premium to compensate the lender for having to reinvest that money at a lower interest rate. And sometimes, when you have a large enough decline in interest rates, that can be a very large number, a substantial percentage of the principal amount of the debt. We also have to face the fact that for lenders, if they have not invoked a default rate of interest, in other words, usually 2 or 3% higher interest rate, before bankruptcy, they ordinarily are not entitled to do it after bankruptcy. Somebody came up with the clever idea of providing that if the company, GMX, went bankrupt, then in that event, the make-whole premium would become due automatically. So we now have this wonderful litigation, which is several weeks from conclusion out in Oklahoma City, where in essence it looks to me like these lenders are using the theory of a make-whole premium to be able to, shall we say, impose a substantially higher interest rate. I make no prediction about how this comes out because, as I said, typically make-whole premia are enforced in bankruptcy courts. It is a case that we will need to follow.
All right, all eyes on Oklahoma City for that one. And for the case of the week, we have a tie this week. It's between two big cases, Lehman Brothers and the ResCap case. They're both pretty important, so let's treat them together. Bill, take it away. What do we have here?
Well, they both arise from decisions within this past week from the U.S. Court of Appeals for the Second Circuit in Manhattan. The most important decision was from ResCap, and methinks it arises because of what I'll call inadvertence or a slip of the tongue by the judges who wrote this unsigned per curiam 5-page opinion. What they said in rather flat terms was, and unqualifiedly, is that the automatic stay may apply to non-bankrupt affiliates and executives of bankrupt companies. This is a big deal because when you change the words around, it means that if somebody continues a lawsuit against non-bankrupt affiliates, you may be in violation of the automatic stay. And believe me, Lee, that can be very painful. You could be liable for very major damages and attorney's fees. I think what the circuit court didn't mention in their opinion was that automatic stays are, shall we say, extended to affiliates and to officers under Section 105 of the Bankruptcy Code called the All Writs Act. I don't think people necessarily thought that the automatic stay automatically applied to non-bankrupt affiliates, but now we have the Second Circuit saying that it may. So in other words, if you continue a lawsuit, you may be in very much harm's way if the bankruptcy judge said you should not have done so. The second case is out of Lehman Brothers. This is almost as important a decision. This very much helps out people who are trustees of company stock ownership plans where people are authorized to invest some portion of their pre-tax income in stock of the company. The circuit court told us that if those executives were to sell company stock based upon non-public information, they could be liable. So in other words, executives of these ESOP plans are in essence authorized to be able to continue holding the stock because they're between the devil and the deep blue sea. If they sell based and there is non-public information available to the company, then they could be liable. This is very good news for people who are trustees of these ESOP plans.
Yeah, just when you thought these two cases were all done and wrapped up, they keep making news. Interesting how they keep hanging in there.
Big companies don't die quickly.
Right on. Bill, we actually have a trading desk item today. There's a story in your column about Ice Cube bonds. What is an Ice Cube bond?
It is a construct of two very smart law professors, Edward Younger from Brooklyn Law School and Melissa Jacoby from the University of North Carolina Law School. It is a article they will publish sometime probably around the end of the year in the Yale Law Journal. They call it Ice Cube bonds because they're dealing with the concept that a company in Chapter 11 is often akin to a melting ice cube, where unless you sell it quickly, there will be less value there a few weeks later.
That's what Harvey Miller called some Lehman Brothers assets way back when that case filed, right?
Exactly. Right. The problem is, however, the process is developing in bankruptcy these days to sell huge companies sometimes within 6 weeks or less. This bothered the two professors because, frankly, sometime you may make a mistake. The price may be too low, or it may be learned later that there actually were some assets that were not subject to the lien that these buyers got. So what they want the buyers to do is, from out of the purchase price, you set aside something called an Ice Cube bond, maybe 10% of the purchase price in their thought, so that if you determine later that there really was value not subject to the lien, or the company was sold for too little, then subordinate creditors will be able to realize against something. I rather suspect, Lee, that this is a notion that bankruptcy judges are not going to have the guts to impose on their own. But I think it is the first step in what should be a very important critical analysis of these quickie bankruptcy sales. And by the way, for practitioners out there, this is an article to read because it has a wonderful compendium of other authorities dealing with quickie bankruptcy sales. And for that reason, by itself, I recommend your reading this very nifty article. And because it's not published yet, I suspect that if you call the professors, they will be happy to send you a draft.
Stay tuned. And we are going to close with the advance sheets. And for this one, we're traveling out to Las Vegas for yet another opinion by Bankruptcy Judge Bruce Markell, who left the bench, of course, last week to go teach at Florida State University. What did Judge Bruce Markell say in his last opinion from the bench?
Well, I got to tell you, Judge Markell was making important law to the bitter end. Every time I thought he was through, here would another opinion come out just as he was going out the door.
Yeah, we're going to miss reading his stuff.
Oh, yeah, I got to tell you.
He gave us a lot of good fodder over the years.
Absolutely right. Well, this decision was had to do with involuntary petitions. He said that when the bankruptcy law in Section 303 was amended a few years ago, it changed the law on involuntary petitions in a very big way. Previously, courts had held that if there was a creditor filing an involuntary petition whose claim was disputed, that creditor could be an involuntary petitioner for the undisputed portion of the claim. Judge Markell said no. As a result of the amendment to the statute, if any part of the claim is disputed, then that creditor is not entitled to be an involuntary petitioner even for the undisputed portion. This is a very, very significant major change. I suspect from my conversations with others that other judges are going to come to the same conclusion. It's not a foregone conclusion, but nonetheless, this is a significant opinion thanks to departing Judge Markell.
All right, Bill, thanks for that. That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.